So this is the Administrative Enforcement Against Counterfeit Goods panel discussion. Second part, I'd like to introduce the panelists. From Indonesia, we have from Ministry of Law and Human Rights, Mr. Ahmad Rifadi. From Malaysia, Ministry of Domestic Trade and Consumer Affairs Enforcement Officer, we have Mr. Hamza bin Mahadi. From the Philippines, Intellectual Property Office of the Philippines, Mr. Theodore Pascua. From Singapore, Bacon McKenzie Law Firm, Mr. Andy Leck. Commentator, we have Mr. Kurose Masashi from Kurose IP Management. Moderator is Mr. Kuroki Kota from the ICD of Ministry of Justice. And so those are the panelists, and I ask Mr. Kuroki, moderator, to take the floor, please.
Yes. Good afternoon, everyone. My name is Kota Kuroki. I am a judge in Japan, but currently working as a professor at the International Cooperation Department of the Research and Training Institute of the Ministry of Justice of Japan, which is providing legal technical assistance to Asian countries. I will be a moderator of this session. In this session, we will talk about administrative enforcement actions against infringing and counterfeiting products. Next slide, please, sorry. Let me briefly introduce about our schedule today. For the first 10 minutes, I, as the moderator, will explain about time schedule, case and questions, and make a little comparison of the answers between countries. For about 75 minutes, we will have panel discussion with panelists from 3 countries, Malaysia, Philippines, and Singapore. Our panelist from Indonesia is not able to join us today. Each panelist will briefly make a presentation about the measures taken by their respective countries against counterfeiting goods within 10 minutes each. It may include answers to case and questions, but it doesn't need to include all answers because it is difficult for them to make it within 10 minutes. So we let panelists decide what they want to emphasize or what they want to talk about here. Each time after each presentation, the commentator, Mr. Kurose, parent attorney with a lot of experience in counterfeiting in ASEAN countries, will make some short comments within 3 to 5 minutes. Also, please allow me to say wrap up, please, when the presentation time is over. Next slide, please. This is a case we already uploaded on the website. We are going to see how the right holder can solve the case with counterfeiting from the contact to certain organization. The right holder company A has the trademark for clothes as designated goods in your country, as you can see the image earlier. Many t-shirts made by company A have the trademark on the left chest. Company A happened to find company B's goods, which are counterfeiting goods. Company B's mark is exact same one to the trademark earlier. Company B's mark, Alim, is similar one to the trademark. We prepared 2 marks so that we can know how it works and proceeds, especially with similar marks to the trademark. Regarding the paragraph 3, an employee of company A was surfing the internet and found that company B's goods were being sold on the e-commerce site El Shopper, which is the largest online marketplace with more than 100 million products and more than 2,000 shops. With this case, we will also talk about e-commerce site problem later. Next slide, please. Let me make a little comparison of answers. Probably I will focus on a little Indonesia because we don't have panelists today. This is question 1. This is about the question about administrative organization for right holders to contact in the first place. This is a simple question, but are actually the most important question here. In other countries, we don't know where to go to get advice to deal with counterfeiting goods. For example, in Japan, the court or the police is taking a big role of dealing with counterfeiting, but we don't have any good administrative system for that. As we can see on the PowerPoint, in Singapore, they have private investigation, and they can hire a private investigator. And in Philippines, they have Intellectual Property Office of the Philippines Intellectual Property Rights Enforcement Office, known as IPOPO, IEO, or they also have local government units. In Indonesia, they have Directorate Investigation and Dispute Settlement Department of Directorate General of Intellectual Property, known as DGIP, sorry. In Malaysia, they have MDTCA. We will talk about it later. Next slide, please. This is a question about organizations that support infringement decisions, especially about the initial decision maker and who support it. For example, when the police has to decide on whether there has been infringed or not, since they don't necessarily have experts on intellectual property matters within the police, in such case, they can have some help from experts outside. This is a question all about. So as we can see on the PowerPoint, in Indonesia, our investigators will ask for expert witness from DGIP or academics. And in Malaysia, the MDTCA enforcement officer can make the decision, and they don't need to rely on the support of external expert, but sometimes they can have. And in Philippines, our IPOPHLPLA makes the decision, and deciding value requires experts from our parties as well. And in Singapore, they can hire a licensed private investigator to conduct surveillance and investigations against the counterfeiting. Next slide, please. This is a question about documents to be submitted. We have answers from all panelists, and I noticed that almost all countries are on the same page on this matter. Generally speaking, we need to submit our number 1, identification of the right holder and the infringer. Number 2, trademark registration certificate. Number 3, evidence of infringement such as samples and photos of infringing products, plus sometimes documents that can indicate location where the infringement happened. Next slide, please. This is about procedure from a request for investigation to a remedy or relief. Under the facts of the case, from the standpoint of Company A, what procedures should be followed and what is the average time required to complete the procedure? We also asked, are there any cases where the right holder and infringer reached a settlement before the administrative relief or remedy? I think the panelists will explain the procedure later, so we can skip it here. Next slide, please. This is about fines and other sanctions. The question is, what kind of sanction will be imposed on the infringer upon a decision of infringement? Also, which organization, such as police or other administrative organization, will order payment of the fine? For example, in Japan, there are no administrative penalties, only criminal penalties are there. This is ordered by the court, not by the police or not by other administrative organization. But in ASEAN countries, as we can see as a PowerPoint, for example, in Philippines, director of the PLA may impose administrative fines. Also in Malaysia, MDTCA will impose payment. Also, in Indonesia, this is just criteria for the fine, I think. Next slide, please. This is a question about burden of expenses. We have answers from all panelists, and I noticed that in some ASEAN countries, right holders don't have to bear any costs. But on the other hand, in some ASEAN countries, right holders have to pay the cost of chartering a truck to transport the counterfeiting goods or the storage cost, etc. For detailed information, you can see the PowerPoint here. Next slide, please. This is the final additional question. This is about e-commerce sites. Especially, we can talk about what administrative organization can do to delay counterfeiting goods on the e-commerce sites. We have answers from all panelists, and I noticed that in some countries, we just needed to go to the e-commerce site or platform to delete or take down the website or account. But on the other hand, in some countries, certain administrative organization can do something such as making a written request to the e-commerce site and so on. So, for example, in Indonesia, for copyright infringement, IP right holder can apply for removal mechanism to DGIP. But on the other hand, for counterfeiting goods, you must submit it to the marketplace itself. I think panelists can explain a little about it later. So this is all from me. Let me, before going to the panel discussion, let me introduce about our Mr. Kurose, the commentator here. Mr. Kurose, do you want to say something here?
Okay, thank you. Thank you very much for joining to our symposium. My name is Masashi Kurose. I'm patent attorney and joining this symposium as a commentator. I say the first session, there were several ways to crack down the counterfeit products. One way is to file a lawsuit, civil lawsuit based on IPR in the court. Another method is to file a criminal accusation with the police. It's also possible to prevent the influx of counterfeit products from overseas by working with customs. In addition to this, in ASEAN countries, as a notable means, and administrative accusation, administrative crackdown on counterfeit products are being carried out. The investigation of counterfeit products by government agencies have been very effective in terms of period and cost performance. So today we'd like to discuss the current situation of administrative enforcement actions against counterfeit products in ASEAN countries. Okay, thank you.
Thank you, Mr. Kurose, for your comment. Now, I would like to move on to the panel discussion. I would like to invite our distinguished speakers. First, I would like to invite the first speaker from Malaysia, Mr. Hamza, Enforcement Officer, Ministry of Domestic Trade and Consumer Affairs. Mr. Hamza, you have the floor.
Thank you very much for Mr. Chairman. Good afternoon. Thank you. I would like to thank the organizer, from Ministry of Justice of Japan, for giving us the opportunity to share some of our informations regarding the enforcement of IP in Malaysia. Next slide, please. So my presentation will be based on some of these contents, background, enforcement mechanism, powers under the law, criminal action procedures, IPR, offensive fines, coordination with other government agencies. I would like to share with you some award and recognition by the industry to the ministry itself. Next slide, please. Okay, I'm giving you some of the backgrounds where the MDTCA, our enforcement division under the MDTCA, is entrusted to enforce the criminal IP, where we are established in 1972, and we have so many core duties to do besides enforcing the intellectual property and intellectual property rights. And as for your information, MIPO, Ministry Intellectual Property Corporation of Malaysia, is the custodian of IP law in Malaysia, but for the enforcement for the criminal IP is entrusted to the enforcement division of the MDTCA. So we have around 2,000 over enforcement officers all over Malaysia, where we enforce about 12 acts. Okay. Next slide, please. Okay, I would like to relate that the enforcement mechanism to enforce the criminal IP protection is more about Copyright Act, Trademark Act 2019, Trade Description Act 2011, and Optical Design Act 2000. The Copyright Act, as you know, that it is dealing with the copyright infringement. The trademark is on the trademark infringement, and for the trade description, we always use for the anything that being leading to false or mislead the consumer relating to any trade description. And for the Optical Disc Act, it is more on controlling the production of optical discs at the manufacturing level plant. Yeah? Next slide, please. Okay, these are some of our main mechanism and statutes related, because our efforts, we are concentrating with all these efforts to ensure that the IP are being protected in our country. For first one is we are cleaning up the shopping malls with using the mechanism that we send the reminders to landlord or premises owner, because with these reminders, we are giving them reminders that we are taking actions based on our law. And because some of the landlords are renting out their premises to the counterfeiters and also the copyright infringers, so we give the notices that anybody who rent their premises to counterfeiters or copyright infringers, we can take action against them using the anti-money laundering, where in some of the cases we take action that we seize and we freeze the account of the landlord, where we take some of the portions that they get from the renting out the premises to the copyright infringers or counterfeiters. Okay. For the second mechanism that we do, that we arrest some of the offenders. Okay, we charge the accused less than 1 month, because when we taking action, criminal action, we normally arrest especially for the foreigners who involved in the IP infringement, because we don't want to lose them, because they are the accused or the main witness for that, so that we can arrest them and charge them in court, and then we can speed it up to complete the case. Okay, and another efforts where we take that we remove contents, taking down the infringing websites, because we have our section, special section that do to remove contents. We join with the multimedia and Malaysian Multimedia and Commission, where we take down some of the infringing websites based on the complaint we receive from the copyright owners or the right holders. Okay, and the fourth one, where we do some campaign with the industry, for example, with the Business Software Alliance, who we work with, that we are also doing some of the awareness program with the industry, where we do some of the programs, and also give some of the reminding letters to industry to comply with the copyright. And then for the crippling syndicates, whatever efforts we take, we normally will cripple the syndicates based on our actions. For example, using the Anti-Money Laundering Acts to really go against them, where we freeze the account and also we seize some of the properties, some of the assets of the infringers. Okay. Regarding the amendments of the Trademark Act 2019, which we do some of the trademark amendments, where we enhance some of the provisions where on the trademark infringement, there are 4 sections being introduced to cater the issue on counterfeiting, where anything to do with the trademark infringement, we can really tackling it using the law. So this is some of the importance of the amendments for the Trademark Act 2019. So the public awareness, we are also doing it continually because the public we do regard the public should be aware of the importance of the IP protections. Okay, the awareness to the shopping mall, where we do some of the self-regulatory campaign where the shopping mall owners are invited to some of our programs with them, where they do some of the undertakings that to ensure that all the shopping mall owners or operators will comply with the law, not to ensure that their premises is not offering any counterfeiting goods or any copyright infringement goods. Okay, next slide, please. Okay, with the administrative actions from the MDTCA, we do have all those powers, as you know, that any enforcement agencies will do have, for example, to enter premises, investigations, and to arrest and access to any of the information, digitalized data, and we also forfeit seized goods, and even we do some of the activities on agent provocator, where we do some monitoring on some of the criminal actions that we plan some of the agent provocator, so that we will know what the actual things that the infringers do. Yeah. Okay. Next slide, please. Okay. To introduce you to some of the criminal action procedures, normally identifying targets. When we receive complaint, most of the right holders will come up with the surveillance reports, where they can identify the targets and what is the activities in the premises. So then when they do lodge complaint to MDTCA, we will scrutinize the documents and decided what do we need to have to do the operations. Then in the operation, we'll do some of the search and seizure if needed, and the verification by the copyright or trademark owners is needed when the raid is completed, because it is part of the important evidence that the goods seized infringe or violated by the copyright. Okay, next slide, please. So regarding the fines, these are some of the fines under the Copyright Act, Trademark Acts, and also under the Trade Restriction Acts. Most of it is at the same, similar to other countries, I think. So 2,000, minimum 2,000 per copy, or the origin copy. For the Trademark Acts is 10,000 or 15,000 based on the individual or body corporate. And also same with the Trade Restriction Act 2011. Next slide, please. So we'd like to share that we have the coordination with other enforcement agencies with the Joint Task Force Committee. So it involves the custom at the border, to cater the border, and the police. We do share some of the informations or surveillance or any information to really combat the piracy and counterfeit goods. And these cooperations also undertaken by using the Anti-Money Laundering Act 2001 by Malaysian government agencies. Okay, next slide. Okay, just to share for my last presentation, it's about the what normally we do with the, for example, the ASRO, English Premier League, and whatever the where we receive certificates because these are some of our efforts that are being appreciated by industry. Next slide, please. Just to share with you the impact of this copyright infringement actions that we are doing now. We can see the decline of the consumers accessing the piracy websites, streaming sites, and also they are aware of the notice, the piracy services. It is being site blocking by the MDTCA and MCMC. Next slide, please. Okay, with that, I think because time is for the 10 minutes time, we'll try to complete it in the time that given. Okay, thank you very much.
Thank you so much for your presentation and being punctual here. Mr. Hamza, Mr. Kurose, do you have any comment on that?
Okay, thank you. Terimakashi Mahati-san. I'll summarize the features of the counterfeit measures in Malaysia. As explained in Malaysia, raid actions against counterfeit products are usually carried out by the government agency, the MDTCA. The MDTCA officials have the same authority as the police and can seize infringing goods and arrest infringers. You did not introduce, but it is famous in Malaysia. There is a system so-called basket on brands. And by registering the basket brand trademark in advance, it is possible to quickly take action against the trademark infringing products. Is that right? Okay. After the MDTCA raid is completed, the case is transferred to the prosecution. According to your answer sheet you are formally sending us, some cases are settled by a so-called compound. Compound is used the same means as the settlement, maybe compound, before the prosecutor prosecutes the infringer. It is reported that about 10% of the cases have been settled by compound settlement out of court. So I'd like to ask one question. According to your answer sheet, that the MDTCA can order the removal of the counterfeit product from the website, can order. Does this mean that the right holder can apply to the MDTCA for removal order when they found the counterfeit product on sale online? And at the discretion of the MDTCA, the website operator removes the counterfeit products from the website. Okay?
Thank you.
I think your mic is muted.
You want me to answer all these questions?
Okay, I can hear.
Later. Okay, thank you, Mr. Kurose, for the question that you raised to me. Okay, for your information, we do have the same authority as police in other certain criminal cases. So with those authority, we are given the powers to arrest. But there are some of the procedures that we need to hand over the infringer for the police custody that is under criminal procedure code given in Malaysia. So another thing about regarding the basket open. Basket open, I do not introduce it because I think we take quite long time to explain to you. But for the for quick explanation, basket open where we have the database undertaking from the industry or right holders that they will give cooperation to us when we take action proactively. When we found your product in the market, we can just seize the product based on the information they already given to us. So no need for you to come to make a complaint. There are some industry from Japan, even registered trademark owners that registering their product under the basket open program by the MDTCA, that we can take actions based on that database. So we can take action and then we will inform the right holders that their products being infringed, and we have already seized those products, and we would like to ask them to come and do some verification report. Okay, where the compound of the cases, normally the compound will be based on the amount or the penalty of the offences. But there are some of the procedures, because if there is a really case that the seizure is very much or very high, normally our deputy public prosecutor will decide the case not to compound the case because of the sensitivity or because of the maybe the public concern on the case. Okay. Regarding the order to remove from the website of any of the infringing offering the infringing goods or copyright infringement products, the MDTCA for the copyright, we can remove it from the website by ourselves. But for the infringing of the trademark infringement, we are working and communicating with the MCMC, with the Multimedia, Malaysian Multimedia and Malaysian Multimedia Commission, where they can remove from the website. We have some information that some of the trademark infringement regarding some of the brands being infringed in the website. Then we work out with the MCMC, where they remove the website from the website, and then they deleted it from the website. That's what it means. Thank you very much.
Thank you very much. Very, very important news. Thank you very much.
Thank you so much, Mr. Hamza. Now, I would like to invite the second speaker from Philippines, Mr. Teodoro Sensei, Deputy Director General, Intellectual Property Office. Mr. Teodoro Sensei, you have the floor. I think your mic is muted, sorry.
Okay. Good afternoon to everyone. Konnichiwa. The Intellectual Property Office of the Philippines, or IPOPHIL as we call it, is the government agency mandated to administer and implement state policies on intellectual property to strengthen the protection of intellectual property rights in the Philippines. Now, I will just go briefly on the existence of another administrative body, which is called the National Committee on Intellectual Property Rights. This administrative body consists of now 13 government agencies chaired by the Department of Trade and Industry, but the Department of Trade and Industry this year designated the Director General of the Intellectual Property Rights or the Intellectual Property Office of the Philippines as designated chair, and the vice chair is the Intellectual Property Office. I mention this because there are agencies in the NCIPR which acts collectively as a body for policy and for joint collaboration. They can do administrative enforcement for intellectual property rights. For example, the Bureau of Customs can do administrative action confiscating counterfeited goods that come to the shores of the Philippines through the shipping ports or our airports. They do it without any judicial support. They can do it as an administrative body, confiscate it, and upon verification that it is counterfeit, submit it for destruction or disposition. The second office which can do administrative action is our Food and Drug Administration. This is as far as medicines and food are concerned. Another agency is what we call the Optical Media Board, who can confiscate or which can confiscate, they call it memory devices, which are not registered in the agency. But these are specialized agencies who work together with the Intellectual Property Office in the National Committee of Intellectual Property Rights. May I go then now to the main agency, the Intellectual Property Office of the Philippines. Next slide, please. Next slide. The Intellectual Property Office of the Philippines is an administrative office that can protect and enforce intellectual property rights. Other non-administrative actions can either be criminal or civil actions or both. But in this instance, you have to go to court to do a civil or criminal complaint against intellectual property rights like counterfeiting and piracy. But for administrative action, you can go to the Intellectual Property Rights Office with a complaint before the Bureau of Legal Affairs. The Bureau of Legal Affairs settles complaints, particularly one for inter partes cases like conflicts on registration of intellectual property like trademarks, the cancellation of trademarks, patents, utility models, and industrial design, or for compulsory licensing disputes. The second jurisdiction of the Bureau of Legal Affairs is in violations of copyright and other intellectual property rights where damages more than 200,000 are claimed. The second administrative office within the Intellectual Property Rights Office or Intellectual Property Office is our Intellectual Property Rights Enforcement Office, which we commonly call IPO. Now, the third one is what we have just instituted. This is conducting mediation outside litigation, meaning to say, if there are competing rights to a trademark, you can file for mediation even if there is no case pending yet. Let us go first, next slide, to some quickly changes in the judicial procedure. In the judicial procedure, we have just had our Supreme Court approve revised 2020 guidelines on enforcement of intellectual property rights. I will not go over these distinctly or detailed, but just to tell you that there have been substantial changes in how court cases are handled all the way from the regular lower courts up to the highest court of the land. Notably, in the disposition, destruction, or also in the a period to decide the cases. Next slide, please. In the Intellectual Property Office, the administrative action was instituted through the law that made the Intellectual Property Office, which gave or showed that the Director General has enforcement and visitorial powers in order to enforce intellectual property rights. The first memorandum order was issued in 2013, which granted or which specified the enforcement actions that may be done by the IEO or the Intellectual Property Rights Enforcement Office. This was supplemented only this year by a revised set of rules on administrative enforcement, which became effective March 3, 2021. Particularly, the jurisdiction is on manufacturing, importation, exportation, distribution, trading, displaying, broadcasting, streaming, offering for sale, including other preparatory steps necessary to carry out the sale, or if you are selling counterfeit and pirated goods. Now, we can do site blocking if the site does counterfeiting activities or pirated activities. Next slide. The Intellectual Property Office can receive from the public a report. We do this by receiving from the public either by email or through Facebook complaints of suspected counterfeiting or piracy. In the slides, you can see where you can send your email or your Facebook complaints. It can be identified by any member of the public, or it can be anonymous. Next slide. And this is how we handle reports. The reports are assessed by a employee or Intellectual Property Rights Office employee, and if it is warranted, the facts, the submitted evidence, and the questions that are asked clearly show copyright infringement or piracy, then we proceed to notify the intellectual property rights owner. If the evidence does not warrant any action, then it is dismissed. We notify the intellectual property rights owner, which can be the trademark owner, the patent owner, or the design owner or copyright. Secondly, next slide please. If the copyright owner or the intellectual property rights owner would file administrative complaint not with the Bureau of Legal Affairs, but with the Intellectual Property Rights Enforcement Office, then we can investigate, see that all the evidence are in, and the things that we can do are visitation, and if it is found that violations are being done in the area, then we can issue a cease and desist order, but we cannot confiscate the goods. Thereafter, if the order is not followed, we take other actions like collaborating and coordinating with the local government for closure or for the cancellation of the business permit where the counterfeiting is being sold or pirated goods are being marketed. We can also take down, with the help of the National Telecommunications Office, any website that purveys pirated goods. In summary, these are the next slide. These are the actions that can be done by the Intellectual Property Enforcement Office. We issue warning to the respondent to observe the Intellectual Property Code. We do visitorial actions in the subject premises where the reported and verified counterfeiting or pirated goods are being purveyed, sold, or kept. We issue compliance against the respondents. We conduct enforcement monitoring after the issuance of the order to cease and desist. And if it is not followed, we coordinate with the local government to cancel the business permit and provide closure. We also coordinate with the National Telecommunications Office to take down the websites if the ISP does not voluntarily take down the website that is purveying pirated goods or counterfeit goods. Finally, next slide, you will see here the final details where you can report violations, and by email, by Facebook, and that is how we have received numerous complaints this year, more than in the previous years that IPOFIL has been existing. The public is very active in reporting. What we need, however, is the support of the intellectual property rights holder to pursue the complaint and to actively enforce his rights. Amendments to this law is currently pending before the Philippine Congress so that we can enforce and strengthen our enforcement capabilities. Thank you very much. Arigato.
Thank you so much, Teodoro Sensei, for your wonderful presentation. Mr. Kurose, do you have any comment on the presentation?
Salamat, Teodoro-san. Thank you. According to instruction explanation, the NCIPR, National Committee on IP Rights, is working and managing the IP issues in Philippines. Yeah. Also, as you explained, the IO, IP Enforcement Office, plays an important role in the investigations of counterfeit products. When the right holder finds a counterfeit product, the right holders can ask the IO to seize the counterfeit products. When an application for seizure is submitted to the IO will judge whether the product is actually an infringement or not. If it is an infringement, the IO can just instruct local police to seize the infringing goods. According to the answer sheet, the period from the applying to the IO for the seizure of counterfeit products to the implementation of the seizure is typically 2 or 3 months. Not so long, very short. So, but however, according to my experience, after the later action, the criminal procedure takes place very long in the court. So sometimes we are settling the cases out of court and as a settlement. So another, you explained the BLA, Bureau of Legal Affairs, is administrative enforcement agency in the IP office, is useful to take actions against counterfeiters. But my impression that the BLA's trial procedure is similar to the proceeding in the court. So giving the defendants the chance the opportunity to respond to the plaintiff's allegations. Therefore, the procedure is quite complex and takes time. So my impression that the BLA is not so suitable as a method for quickly crack down on the counterfeit products. It's mostly not counterfeit, but patent infringement case or design infringement case is more suitable, using BLA. Is that right? How do you think the BL is very suitable for the cracking down the counterfeit.
You're on mute.
Sir, your mic is muted.
Sorry. Okay. Let me clarify again. The IEO does not confiscate counterfeit goods. However, if it is necessary to do so because of the quantity, the complainant or the rights holder must file a application in the courts for search warrant, and in that case can cooperate with the local police or what we call the National Bureau of Investigation. It is the court that will issue a search warrant that can authorize the police or the National Bureau of Investigation to confiscate the suspected counterfeit goods. The IEO can just do what we call visitorial rights of the office to see where the alleged counterfeit goods are being purveyed or sold. And if it is found that it exists there, the respondent or the one holding it is ordered to cease and desist, but we cannot confiscate it. Our pending application to the Congress to grant us the right to confiscate is still pending. On the issue of the Bureau of Legal Affairs, it is true that the Bureau of Legal Affairs acts like a court. It has quasi-judicial authority. The speed by which the BLA can finish a case also depends on the parties involved. If the prosecution or the IP rights holder can move fast, it can even ask for a restraining order or an injunction so that the spreading of counterfeit goods can stop while the case is pending. Is the BLA a viable source for enforcement of intellectual property rights? It is, because right now we have buffed or we have supported the BLA with additional lawyers. Secondly, we have enforced or issued the implementing rules and regulations for mediation so that parties there can easily mediate and agree to a what you call a compromise or settlement, which could be faster than if a case is concluded up to the end. And then finally, if the lawyers or the representatives would just act fast, sometimes the delay is caused by support from the owners who are residing abroad. So documents, evidence sometimes gets delayed solely because of distance or our mail or manner by which documents can be sent. So we are moving very fast to have alternative ways to settle intellectual property rights, either through the courts or through administrative bodies like the Intellectual Property Office, IEO, or the Bureau of Legal Affairs. Thank you, sir.
Thank you very much. You have several channels to crack down the counterfeits. Thank you very much.
Thank you so much, Mr. Kurose and Mr. Teodoro. Now, I would like to invite the final speaker from Singapore, Mr. Rek Andy, Principal Baker McKinsey Wong and Liu lawyer. Mr. Andy, you have the floor.
Thank you very much, Judge Kuroki. Good afternoon, honorable judges, ladies and gentlemen. Before I begin, I wish to express my thanks to the Ministry of Justice and the organizers of this judicial symposium for inviting me to participate. Next slide, please. In this 10-minute presentation, I will begin with an overview of IP enforcement options in Singapore generally. I will focus on criminal enforcement in Singapore, which you may find unique because the option of bringing private criminal proceedings and not public criminal proceedings, I believe, is fairly rare. In the interest of time, I will just touch only very briefly on civil proceedings and border enforcement measures. Next slide, please. There are various forms of enforcement options which exist in Singapore. Next slide, please. These include civil action, criminal prosecution, and administrative actions against counterfeiting or infringing activities. Singapore has a very unique self-help regime which enables the criminal enforcement against trademark and copyright counterfeiting to be carried out by rights holders privately with the cooperation of the Intellectual Property Rights Branch of the Singapore Police, as well as the Attorney General's chambers where the public prosecutors sit. In addition, we have administrative actions in the form of both ex officio and border enforcement measures which are triggered by requests. And these are available under both the Copyright Act and the Trademarks Act. And here the enforcement agency will be the Singapore Customs. As we are speaking about counterfeiting today, I will only focus on trademarks. And in cases involving counterfeiting and counterfeit products, the rights holders usually use a combination of one or more of the three options for enforcement. First, criminal proceedings, and this is the primary method of enforcement. Second, civil proceedings, and third, border enforcement. The specific approach to take and the strategy to be adopted depends on various considerations, including one, the owner's short-term and long-term objectives, two, the owner's budget limitations, three, the time constraints that the rights holder is facing, and last, the scale and the nature of the infringer's operations. Some forms of legal action, like civil proceedings, may incur very high financial costs that may not be commensurate with the value of the desired results. On the other hand, a large-scale counterfeiting operation may justify not just one option, but multiple options. So proper planning and advice from the legal advisors will go some way towards preserving and protecting the rights holders to the full extent that the law allows. Next slide, please. Now, criminal proceedings in cases involving counterfeit goods can generally be conducted in two ways. Next slide, please. So the first is private actions commenced by the rights holders, and the second will be ex officio actions commenced by the IPRB or IP Rights Branch of the Singapore Police. As trademark counterfeiting is a criminal offense in Singapore, you would naturally expect the police to conduct the investigations following a complaint from a rights owner. And after evidence is secured, you would again naturally expect the public prosecutors to prosecute these counterfeiters in court. Now, this method of criminal proceedings is in fact available in Singapore and is what we in Singapore refer to as ex officio criminal action. Generally speaking, ex officio actions are only conducted by the IPRB and by the public prosecutor where there are issues of public safety, such as sale of counterfeit medicines, or where there's evidence of organized crime. Instead, the police and the public prosecutors in Singapore expect the trademark owners to take private criminal actions, which they frequently refer to as co-op, short for cooperative actions. As ex officio actions are irregular and subject to the IPRB's discretion, I will focus on the private criminal actions, as it is more frequently relied upon by the rights holders. It is also quite unique to Singapore's system of enforcement. Next slide, please. Now, under Singapore's Trademark Act, it is a criminal offense in Singapore to import into Singapore, sell, offer to sell, or have in its possession for the purposes of trade or manufacture counterfeit goods. And these offences are punishable by a fine of up to 100,000 Singapore dollars, which works out to about 8.2 million yen, or up to 5 years imprisonment or both. And in the case of selling counterfeit goods, the offence is punishable by a fine not exceeding 10,000 Singapore dollars, which is about 820,000 yen per counterfeit goods, so long as it doesn't exceed the aggregate of the $100,000 ceiling. Directors of companies may be liable for infringement if there is evidence that the offence was committed with their consent. I should add that where the accused is convicted and he is found to have a criminal antecedent, meaning to say that he is a repeat offender, the Singapore court, from past observations, is very likely to sentence that accused to imprisonment, even if he was to sell just one counterfeit item. Next slide, please. In private prosecutions, rights holders bear the responsibility to conduct the investigations and to privately prosecute such offences, as I mentioned earlier. So the rights holders are expected to bear the costs. Now, prior to commencing such actions, the rights holders usually will conduct private investigations into the target to obtain evidence that the target is engaged in infringing activities. And based on such evidence from the private investigators, the rights holders, after authenticating the sample purchasers, will then apply through their external lawyers to the Singapore state courts for criminal search and seizure warrant against the counterfeiter's premises, where the counterfeits are likely to be stored or being sold. Now, typical investigations will include your sample purchases, or whether it's online or in person. It will include background checks into the target, internet checks, and surveillance. Next slide, please. An application for a search warrant is made by the filing of a criminal complaint in court with the support of a statutory declaration by the rights holder 1 day before the raid. Why statutory declaration? It's a requirement because the evidence will be given on oath, and naturally, if there is false declaration given, that in itself is an offence. Now, upon the application by the rights holder, the court may then issue the search warrant if there's reasonable grounds for suspecting that there are counterfeit goods stored at the counterfeiter's premises. And the warrants allow entry into the premises in question and for the search and the seizure of the counterfeits. Now, when I said premises, the premises can include a car, a ship, it could even be a warehouse inside the free trade zone. The officers of the IPRB of the Singapore Police Force will be the folks who will execute the warrants. But the lawyers and the authorized brand representatives can also attend during the raid. But you have to make a special application so that you are in the search party. The scope of the warrants extends to infringing articles as well as any incriminating documents evidencing the commission of the offense, such as invoices and purchase orders or delivery orders. The seized articles are then used as evidence of counterfeiting at the criminal trial. Next slide, please. Now, before criminal charges are drafted and served, the rights holder must obtain written permission, what we call a fiat, from the Attorney General's chambers to prosecute. The Attorney General's chambers, or the AGC, will impose conditions on the lawyer and on the rights holder. For instance, the charges that are framed must be subject to the approval of the AGC. Equally, any plea bargaining must be subject to the approval of the AGC. Once the fiat is obtained, the rights holder's lawyer functions as if he is the public prosecutor, where he may commence criminal proceedings and seek to prove in court the counterfeiting offences discussed earlier. The next slide, please. After the raid, but before any commencement of criminal action, rights holders may concurrently serve a cease and desist letter on the counterfeiter. Now, this is with a view to coming to a private settlement with the counterfeiter. And the cease and desist letter will normally set out first the claim which a rights holder has against a counterfeiter, second, the evidence in support of the claim, and then third, a demand that the counterfeiter signs a deed of undertaking setting out the terms of the settlement in exchange for the rights holder not to pursue further legal action. And a typical undertaking would include first a requirement by the counterfeiter to refrain from further infringing activities, as well as providing full and frank disclosure on oath of the source of the infringing articles and whom he had sold it to previously. Second, payment of agreed damages and costs. Third, surrender of all infringing articles for destruction. And last, a publication of a public apology. The terms of the settlement are to be negotiated and agreed between the rights holders and counterfeiter. And because of the gravity of the sentences against the counterfeiters, and because many counterfeiters do not wish to have a criminal record, the counterfeiters in Singapore are frequently willing to settle on terms fairly favorable to the rights holders. In fact, it's quite common to have such criminal actions run on what we call a self-financing basis. In other words, the settlement sum received should be enough to pay for the rights holders' legal and investigative fees. Next slide, please. As mentioned, besides private criminal proceedings, the IPRB may also undertake ex officio actions, raids, and criminal prosecution by the public prosecutor. And such raids are conducted on the IPRB's own initiative. The IPRB may also act on complaints from the general public or the IPR owners. Next slide, please. Now, in the interest of time, I will not deal with the option of a civil claim. This is common in most parts of the world, and save for the precise rules of court, largely similar in most jurisdictions. I don't think it will be a good use of time. I'm naturally happy to share my PowerPoint presentation with all participants. I will just make 3 points. First, it is possible to apply for an interlocutory injunction to stop the further infringing activities pending trial. Second, it may be possible to seek summary judgment against the trademark infringement, assuming there are no triable issues of fact or law. Third, the rights holders can seek legal costs in the event it succeeds at trial. And finally, there is statutory damages available for trademark infringement. And this is naturally useful where you don't want to share, sensitive pricing information. Can we jump to slide 17, please? So skip the next 2 slides. Yeah, thank you. Now, the last topic, I will just give a brief overview. Next slide, please. Unlike Hong Kong, China, or Australia, Singapore does not have a customs recordal system. But Singapore has what we call border enforcement measures, and there are 2 ways. The first is border enforcement seizures on request. So this is triggered by a complaint submission. The second is an ex officio customs seizure, which is done purely at the behest of Singapore Customs. Next slide, please. So first, seizures on request. Here, the rights holders of registered trademarks may request the Singapore Customs to seize trademark infringing goods that are expected to be imported or exported. Such a notice is valid for 60 days. Upon seizure of the goods, the Singapore Customs will give the rights holder notice that the goods have been seized. The rights holders then has to institute civil proceedings for trademark infringement and notify Singapore Customs within 10 working days after the date specified in the notice to take action. The time limit for initiating the infringement action may be extended for further 10 working days on the request of the rights holder. And in bringing the infringement action, the rights holder should seek, in fact, must seek an interim injunction from the court to prevent the release of the infringing goods by customs. If the action is not instituted during the detention period, or if an order of court preventing the release of the infringing goods is not obtained by the 22nd day after the institution of the action, here bear in mind the non-working weekend days, the Singapore Custom will release the goods to the importer or the exporter. I should also highlight that these proceedings are not that easy, because you need to provide information of some detail to Singapore Customs before they will react. You need to, for instance, provide the name of the vessel, the approximate estimated date of arrival, and so on. So not information that is easily available without some investigations being undertaken. Next slide, please. Now, besides seizure on request, the Singapore Customs, as I mentioned earlier, may also of its own volition seize counterfeits that are imported into or exported from Singapore. After the seizure, the Singapore Customs will give the rights holders notice that the goods have been seized, and the procedure mentioned earlier for seizures on request apply equally here. I should highlight that such ex officio seizures are not very common. They tend to be exercised, again, where there are health and safety issues, or if the counterfeit products are spirits or alcohol or tobacco. As you can imagine, the Singapore Customs get very upset as cigarettes, wines, and spirits carry heavy import duty, which should be paid to Singapore Customs. So that brings me to the end of my presentation. Thank you very much for your attention, and I pause here for questions and observations from Kurose Sensei.
Thank you so much, Mr. Andy, for your wonderful presentation. I was not familiar with private criminal procedures, but it is clear to me right now. So, Mr. Kurose, do you have any comment on the presentation?
Oh, thank you very much, Andy-san. I have some questions. As you explained, Singapore does not have a system for government agency to take action against the counterfeit goods. So main point that in Singapore, private sector right holders have to support the enforcement agency to resolve the counterfeit issues. Is that right?
Not entirely. So as I mentioned earlier, there is this ex officio option. For the ex officio option, the authorities will do everything themselves. They will bear the costs. They will do the investigations, and they will conduct the prosecution. But as I said, they tend to be far and few in between. It tends to be restricted to, firstly, products which will affect health and safety. And secondly, where there is some suggestions of a syndicate or organized crime. In the usual case, you are absolutely right. They do expect the IP owners to contribute. That's why they call it a cooperative action. So what they want is for the rights owners to contribute on the investigations and even the prosecution.
Okay. Okay. Then also in Singapore, it can be said that the cases of infringement of IP rights are generally resolved by civil lawsuits. Is that right? Mainly a civil lawsuit. Criminal suit also?
No, not civil. I would say that for counterfeiting, the primary option is by way of criminal raids, followed by prosecution if necessary. But you will see the criminal enforcement method is a two-stage process. So quite frequently, after the search warrant has been applied and the raid has been executed, and after the counterfeit goods have been seized, the rights holders will issue a cease and desist letter. And they will not start the criminal actions because as I mentioned earlier, once you start the criminal actions by applying for a fiat, everything is subject to the Attorney General's Chamber's discretion. And the one thing that the Attorney General's Chambers does not like is for the rights holders to use the threat of criminal prosecution to secure a favorable settlement agreement. But you can see, the moment you have seized the goods, you don't even have to tell them, if you don't settle, the next thing I'm going to do is to charge you in court. They usually will know, because the police were the ones who had conducted the raid.
Thank you. I see. I think the counterfeit products are very rare sold in the Singapore market. So it seems no special government agency necessary to deal with counterfeit products. So you are very clean market usually. All right.
I think certainly with the improving sophistication of the consumers, there are less in relation to luxury items, but there are still counterfeit products in the Singapore market. But there's many of them have moved online.
Yeah, if the counterfeit products are found in Singapore, the right holder can take actions. You explained again by using the private criminal proceeding system. But however, this system seems to put a heavy burden on the right holders. I'm very interested in about the cost. So have you ever used the private criminal proceeding system to deal with counterfeit products? And how much does it cost to deal with counterfeit products using this system?
Yes, so I have been adopting criminal options as the primary option for a very long time. As I mentioned in the slides, it is in fact quite effective. And frequently you can use it to run almost a self-financing anti-counterfeiting campaign. In fact, I believe, subject to Encik Mahadi's comments, I heard from my partners in Malaysia, they even tried to push for private prosecution in Malaysia. But on your question of cost, I think it is a good one. As a rough estimate, I think for investigations, and you should get a licensed investigator, because if you don't, and investigators are licensed by the Singapore Police, the evidence that you obtain may be rendered inadmissible. The cost is about, I would say, 290,000 Japanese yen, excluding disbursements. If you are looking at the application of the search warrant, so the first step, I would say about 2.3 million yen or $20 USD. And if you still can't obtain a settlement after the raid and you are forced to go to trial, then, as you know, the process becomes very adversarial and the figures can range. In some cases, after the charges are framed, they will plead guilty without a fight. And it can be as little as, say, 570,000 yen. Right? Or if it goes to a 3-day trial, which is very long for criminal trials, it can come up to about 11.5 million yen.
Yes, thank you very much. A little bit hesitate to take action using private sectors. Yeah, and also the border measures. The border measure is, my impression, is not easy in Singapore.
That is correct. It is not easy.
Okay, thank you very much. So my impression in Singapore, the counterfeit products, how to see the counterfeit products is not easy to the Japanese companies. Main point is cost. Okay. All right. Yeah. Okay. Thank you very much.
Yes, thank you so much for your comment from Cross Sensei, and thank you so much for your presentation from Andy as well. Anyway, we have reached the end of working session 2, and I would like to have 5 minutes more on the question and A session. So I wanna restart it for Q&A session from 5:15, so that we can have more time, especially for working session 1. So I'd like to say thank you so much for your wonderful discussion for working group 2, and we also have another Q&A session from 5:15. We would like to welcome you if you are available again. So now we will take 15 minutes break from now.